The notice that is challenged,
It's a fresh matter. I had to give a copy to.
26/4/23, what is the notice?
My lords, that's a notice issued by BDA that they have provided 5 crores, 5 crores and odd they have transferred, my lords, but we have requested for 40-60 ratio, my lords.
Well, representation consideration, that's all.
Wait, annexed
Wanted to-
Identical matter.
Yes.
Can close it
Yes,
by directing consideration of the representation.
yes, ma'am.
The petitioner is before this court seeking the following prayer. The heard words. The petitioner claims to be owning a property which is now subject matter of acquisition for the purpose of formation of Dr. Shivram Karant layout. The grievance of the petitioner is that the impugned notice does not recognize the compensation
No, my lord, 60-40 ratio.
does not recognize the scheme of 60/40 ratio for the acquisition of property of the petitioner. And in that light has submitted plethora of representations. The 3 of the representations made are appended to the petition as annexure N, P, Q, and R and S. The representations have not met their consideration at the hands of the respondent BDA. Even today is the submission of the learned counsel appearing for the petitioner. Generally, when a representation is submitted, it is the duty of the authorities to redress the grievance of a citizen as submitted in the representation with representation in accordance with law. In the light of the representation not being considered even today, we deem it appropriate to direct the BDA to consider the representations submitted by the petitioners, annexures of which are noted here and above, within an outer limit of
6 weeks.
8 weeks.
8 weeks.
Outer limit of 8 weeks, if not earlier. The decision taken shall be communicated to the petitioner, if not earlier. Decision taken shall be communicated to the petitioner. It is made clear that we have not assessed the merit of the claim of the petitioner. All other contentions, all contentions on the merit of the matter shall remain open. Of the parties shall remain open, ordered accordingly.
Notice has to be issued to.
Huh?
In the beginning, my lord, let notice be issued to me.
Correct. Beginning already. Separate order sheet Madi. Learned counsel Shivaprasad Shantan Gowda is directed to accept notice for respondents 2 and 3. Learned AGA for the state. Petitioner to sell 2 sets of petition papers upon the council for the BDA forthwith. At separate Madi. Ido separate order. Heard words. Road.
Now, there are about 7 matters in which I appear.
True.
I've just
But
prepared
all the matters are road matters.
On road. Following.
all a road matter.
Barring my lord, I will just point out the serial numbers. Serial number 5. Serial number 5. Serial number 6.
Onondak tagu.
Please, please.
Let's, my respect, I've just prepared a brief note. Minutes.
There are certain structures, my lord, which have been regularized.
Hmm.
And there are certain structures which have not been regularized.
Hmm.
My lord, treating them on the same footing may not be correct. Learned AG, my lord, on the previous occasion made a submission
Hmm.
that insofar as regularized buildings are concerned, if a road was not passing through it, that building would have been saved. So as a compensation, my lord, on a land-to-land basis, let us assume, my lord, for a moment that 1,000 square feet is lost. 1,000 square feet on which the building is standing. They will be allotted 1,000 square feet plot. And the building compensation also will be added on to it, because otherwise they are entitled for only 60/40 scheme. So in the respect to that also, my lord, the committee also made a similar recommendation. However,
I've
that was
produced
not
that in my
considered.
note.
Ilidiya.
Ide. I'll just make a few submissions. Minutes.
That's at page 43.
Please.
Yes.
Let's now, in the matters which I appear, broadly, Millets, it's acquisition under 2 separate notifications. One under the original scheme. The second acquisition is under a specific acquisition only for the purpose of formation of a road. This
Separate
was
acquisition.
issued, yes, Millets. About 45 acres has been acquired only for the purpose of formation of a road. Now, Millets, these 2 sets of notifications will have 2 separate sets of cutoff dates. The sense, Millets, the original scheme will be 3rd August 2018. The other scheme will be prior to the preliminary notification issued for the purpose of formation of the road. In the matters which I appear, my lords, either the constructions have come up prior to the notification or prior to the cutoff date and have been regularized by the orders of the Honorable Supreme Court, or have come up prior to the preliminary notification and are eligible for
2008
regularization.
2008 preliminary notification.
2008 Ali, cutoff date being 8 2018.
2018.
I'm eligible. I have been regularized also in some cases. The other, my lords, insofar as matters relating to formation of a road, those several persons I'm given to understand, subject to correction, that they had filed applications before the committee. Certainly, my lords, because it is going for the purpose of the road, the committee would not have regularized it. Therefore, I am otherwise eligible for regularization.
Yes, ma'am. There are
Your
certain
lordship
build-
may
And in the alternate,
please,
entitled to
Please.
share-based allocation of sites.
yes, please. Your lordship.
Ratio-based.
There were certain buildings which were come up before the date of final notification or 3/8/2018 or before 2022, the preliminary notification date. But those buildings were not regularized only on the ground that those buildings are falling under RMP road. Otherwise, my lord, they ought to have been regularized.
My lords, now your lordship may kindly take page
ಅವಾಗ
3.
ಈ compensation. for the
Compensation.
area plus for the structure
Building.
they exist. ಅದು
See,
No.
if the road is passing by,
23,
we cannot
24.
save that. Except the compensation and for the building. What
Please.
uh,
Please.
lordship-
In that background itself, my lords, I'm just page 3 is the order of the Honorable Supreme Court, where, my lords, in blanket terms, whether road is passing or not, constructions ought to be saved.
How?
But I'm not seeking for saving of construction. I'm only pointing out
What Supreme Court said.
what the Honorable Supreme Court said, which is categorical that constructions
ಯಾವ್ದು
pri-
ತೋರ್ಸಿ, ಯಾವ್ದು
Page 3.
para ಹೇಳಿ.
para 2 would be relevant, my lords, but at para 5 is where the
Para 5 is what?
Landowner
please
will-
para 5 last 3 lines, my lords. However, your lordship's got that, my lords, at page 5.
Page 5. However,
However, bottom 3 lines ಕೆಳಗಡೆ.
However, where a person is-
However, where a person has constructed a dwelling house or any other building, and where the constructed portion is not adjusted for any reason, betterment charges could be levied under section 20. This would be relevant. BDA is directed to integrate the said constructions into the layout. So therefore, the build
subject to possibility. So
possibility.
court cannot direct performance of something which is impossible.
Therefore, my lords, now would your lordship be kind enough to take page 10? This is, my lords, a recent judgment of the Honorable Supreme Court. Please. In this, I only wish to rely upon one point, my lords. Page 33, 30.5. 30.5 deals with the right of restitution or fair compensation. Now, I'll put it, it's a settled principle. I'm only putting it this way, my lords. In most of these cases, had it not been for the change in alignment of the road or formation of the road, I would have, my lords, this side, I would have paid betterment charges and I would have obtained. In several cases, they have changed it. Therefore, to maintain parity with me, with
The alignment.
yes, in several cases they have,
So we have
After
said
the
wherever possible.
implication.
wherever possible.
Okay.
But that would certainly be so, the necessity because of large scale regularization that have happened, alignment has been changed. To save one construction, other constructions will have to go. Now that in several cases the roads have already been formed, I'm not going to harp on that argument specifically. I'm only trying to point out to your lordship's minutes that I must be put on par with respect to other landowners whose lands have been regularized. Therefore, in this background, my lords, the committee's recommendation assumes significance. Your lordship may now take page 43, which is the recommendation of the committee. This, my lords, is dated 21/8/2023. May I read, my lords? In the course of execution of the layout, certain roads have been re-engineered and alignments have been modified depending upon the topography. As a consequence, now it is found, in a few cases, building exists and alignment of the road fully or partially. The best course of action in these cases is to follow the procedure that was followed at the time of construction of intermediate ring road so as to avoid unnecessary litigation and consequent slippage in work. The following procedure therefore needs to be adopted.
The recommendation appears to be
Yes.
1 and 2, page 44.
Yes,
1
yes.
and 2.
Even learned AG also made submission that it's a fair, yes.
But it's now
But
what
that does not provide for protection of the building. If they fit into 1 and 2 parameters,
please.
they have said what should be done.
Yes.
All judgments relating to retention of property with the owner are subject to eminent domain.
Please. No, no. Therefore, my lords, in this, your lordship may now just take page 2 of my notebook. In the background of this, this is what, my lords, I have sought for. In essence, if all the matters are connected, general directions may be issued. Since a large number of constructions have come up, petitioners pray the following directions may be issued. A, identify the constructions which have come up prior to the cutoff date. My lords, this can be done in reference to Google satellite image itself. Then,
So
my lords,
you are agreeable for these conditions?
But if it's an order of the court, my lord, will.
Oh, that's what,
Yes,
order of the
yes,
court.
yes, yes.
Why should we?
Because
that's what.
Because learned AG also made the same submission, saying that it's a fair argument, my lord, where my
No,
learned
you
friend is
have,
making.
you have said what the committee has said in a little more detail.
In a little more detailed manner, the other directions I've specifically sought for, my lords, is now point B is the determination of the extent of land which I would be entitled to. My lords.
No, no, no. Determination of extent of land and building required for the purpose of formation of road. Then accordingly determine siteable area, then you are tweaking into the acquisition. That can't.
Yes.
No, my lords, it's like this, my lords. If in a 2030 site, I've put up about 800 square feet, my lords, I should, my lords, in all probability be entitled to a 2030 site itself on land to land basis.
Land to land basis.
Correct. Because this is not 60-40, my lords.
That's what committee said on.
That's
That's what the committee
said.
has also said. Ashtidre Saab. Now, therefore, the only other prayer that I'm seeking, 2 other prayers that I'm seeking is, in some of the cases, the compensation has already been deposited before the civil court.
They will have to rework that.
Yes,
Adರಲ್ಲಿ,
Yes.
if
Work ಮಾಡಿ
we'll have to rework.
rework, if your lordships issues a direction
Yes.
that BD is permitted to withdraw the compensation insofar as the road, insofar as the value of the building, that would suffice, my lords. Because if I am, my lords, relegated back to the civil court only for the purpose of
No, no, now everything
ಮಾಡಿದೆ.
will be closed here only.
yes, one last minute that I've sought for. It's in some of these cases, almost all of these cases, they are residing there. I have requested for reprieve of about 3 months, my lords.
ರೀಸನೇಬಲ್ ಟೈಮ್ ಕೊಡಕ್ಕಾಗ್ತದೆ ಹಂಗೆ ಅನ್ಕೊಂಡು ತುಂಬಾ ಜಾಸ್ತಿ ಕೊಡ್ಲಿಕ್ಕಾಗಲ್ಲ ಒಂದು ರೀಸನೇಬಲ್ ಟೈಮ್
You
ನಲ್ಲಿ
have sought 12 weeks.
12 weeks.
ಕೊಟ್ರಾಯ್ತು
12
12
weeks.
weeks ಕೊಡು
Please.
That's it.
3
Apart
months
from this,
ಬೇಕಾಗ್ 12 weeks ಗಿಂತ 3 months ಮಾಡಿ
Because they have to relocate.
yes,
3 months ಮಾಡ್ಬೋದು ಒಂದ್ 4 ದಿವಸ ಜಾಸ್ತಿ ಆಗ್ತದೆ
ಅಷ್ಟೇ.
ಇಮಿಡಿಯೇಟ್ಲಿ ನಾವು
Yes,
ಹೊರಗೆ ಹಾಕ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. We are not Bangladesh. We are a matured democracy in the globe. Alwa. So naturally, all these things we have to. That's what. We are the finest democracy.
So how many matters are there? ನಿಮ್ದು? Road ಯಾವ್ಯಾವ ಇದೆ?
Everything barring serial number 5,
ಹಾ,
6.4.
ಒಂದು ನಿಮಿಷ. 3. ಒಂದು ನಿಮಿಷ. 3, 4 ಏನು?
ಎಲ್ಲಿದೆ?
ಒಂದು ನಿಮಿಷ. ರೋಡ್ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. ನೀವು ಅಲ್ಲೇ ಇದೆ.
ನಾವು ಅದೇ ರೋಡ್ ಅಲ್ಲಿ
ಅದೇ ರೋಡ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 4 and serial number 10 to 15.
ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ ಅವ್ರದಾ?
ಹೌದು.
ಎರಡೂ
4 and 15, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 10.
4, 10 to 15.
4, 10, 11, 12, 13,
15.
15.
And a
ಎಲ್ಲ
note per
ಎಲ್ಲ ತಾವೇ
particular
ಬೇರೆ
number,
ಹಾಕಿದ್ದೀರಾ?
Yes.
Memo.
ಈಗ what fell from Rohan
ಹಾ.
and what is accepted by the BDA is acceptable.
I couldn't
That is
get
the
it.
fair solution.
No,
ಅದ ಕಮಿಟಿ ಒಂದು ಆರ್ಡರ್
ಆ ರಿಪೋರ್ಟ್ ಎರಡು ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಫಿಕ್ಸ್ ಮಾಡೋದು.
ಮಾಡಿದ್ದಾರೆ.
Page 43 ಬನ್ನಿ.
ಅಲ್ಲಿ ಸರ್ ಕೊಡಿ.
Rao is also here in these matters. Mr. Rao? Are you in these matters also?
6.3 and 6.5.
So are you also on the same road?
Yes.
He is also on the same road.
Only a few facts and submission on facts, my lord. Just to give a memo in all these cases. There in the first page, my lord, I have prepared a table. Now, first WP 14371, it is a 15 to 25 feet side. He has borrowed, my lord, 45 lakhs so and so, license is obtained, 4 floors have been constructed and they have been let out. Then second is the Rukma Devi's case also, 3 floors and they are residing in that building. Serial number 3 is again 4 floors.
Idರಲ್ಲಿ, is it lawful to put up 4 floors in a site of that dimension?
We have taken a license plot on 2010 by the Panchayat.
ಎಷ್ಟು ಫ್ಲೋರ್ಸ್ ಗೆ
ಎಷ್ಟು ತಗೊಂಡಿದೆ?
ಪಂಚಾಯತ್ ರೂಲ್ಸ್ ನಲ್ಲಿ ಎಷ್ಟು ಪರ್ಮಿಸಿಬಲ್ ಇದೆ?
ಇಲ್ಲ 50-25 4 floors.
4 floors.
Ground plus 3 is permissible, my lord. More than that,
Even in
it becomes.
1523.
Ground plus 3 is
ಅಲ್ಲ
permissible.
site area is 50-25.
50-20.
50-20.
20, first
Other-
serial number 2.
Ah.
3 is 50 to 25, 4 floors.
Let us see the normative basis of the vertical construction.
Yes. Then, my lord, I'll just give the
Okay.
facts. Then serial number 5, 3 floors and they are residing there. Serial number 6 also, my lord, they are residing there. Then, my lord, at the next page is the photograph. Serial number, page number. Immediately next page is the photograph. Out of that, one building is regularized.
ಯಾವ ಬಿಲ್ಡಿಂಗ್ ಅದು?
ಅದು ಏನು ಪಿಂಕ್ ಕಲರ್ ಇದೆಯಲ್ಲ?
ಪಿಂಕ್ ಕಲರ್
ಹಾ.
ಬಿಲ್ಡಿಂಗ್ ಪಿಂಕ್ ಕಲರ್
ಅಲ್ಲ ಪಿಂಕ್ ಅಲ್ವೇ ಅದು?
ಇಲ್ಲಿ
ಹಾ, ಹೋಟೆಲ್.
ಕಲರ್ ನೋಡ್ರಿ
Remaining, my lord, are the adjacent buildings or the.
ಅಕ್ಕಪಕ್ಕ ಎಲ್ಲ 2 floors 3 floors ಇದೆ, ಇವ್ರದೊಂದು 2
4
floors.
floors ಕಟ್ಟಿದ್ದಾರೆ.
ಹಾ?
ಇಲ್ಲಿರೋದು
ಅದೇ ಅಲ್ಲಿ ಕೆಲವು 2 floors ಇದೆ. Then in the
Mostly,
next.
they went
Seeking
to Burj-
compensation for that entire action may not be.
they have
Let that keep it.
they are inspired by Burj Khalifa.
If they obtain
ಅಲ್ಲ
permission and-
ಬಿಲ್ಡಿಂಗ್ ಅನ್ನ ಹೊಡಿಬೇಕಾದ ಅವಶ್ಯಕತೆ ಇದೆಯಾ ಅಂತ ಪ್ರಶ್ನೆ. ಅದು ಬೇರೆ ಕಾಂಪನ್ಸೇಷನ್. ಇವನ್ ಅದರ್ವೈಸ್ ವಿ ವಿಲ್ ಬಿ ಎಂಟೈಟಲ್ ಫಾರ್
ಅಲ್ಲ
ಕಾಂಪನ್ಸೇಷನ್.
ಇದು ಕಮಿಟಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಈ ಕೇಸಸ್ ಅಲ್ಲಿ?
ಕಮಿಟಿ ಒಬ್ರಿಗೆ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ದಟ್ ಪಿಂಕ್ ಫ್ಲೋರ್ ದೇ ಹ್ಯಾವ್ ರೆಗ್ಯುಲರೈಸ್. ರಿಮೈನಿಂಗ್ there are 1 or 2 days immediately after the Supreme Court order. Remaining, my lord, is only 2-3 days after the Supreme Court order, license is granted.
But if the road
Even
has to be
before the
widened,
order of the Supreme Court is made known.
if the building is regularized and the road has to be widened, my lord, they're entitled for that
Compensation.
enhanced compensation.
No,
also.
compensation is all
ಅಂದ್ರೆ
right.
Once it is
ಏನ್
regularized-
ಮಾಡ್ಕೊಳಿಕ್ ಬರ್ತದ? ಈಗ what Rohan said is, wherever possible, you have to retain. They should be permitted to retain.
That is.
ಅದನ್ನ ಕೆಡವಿ ಅದಕ್ಕೊಂದು ದುಡ್ಡು ಕೊಟ್ಟು ಅದೆಲ್ಲ ಮತ್ತೆ ಸೈಟ್ ಏನ್ ತಗೊಳ್ತಾರ ಅವ್ರ ಮೇಲೆ ತಲೆ ಮೇಲೆ ಬರೋದದು.
The number of petitions before the court are 20 numbers. I am told, my lord, in so far as buildings coming on road are concerned, there are 200 odd such structures. After taking deviations in parallel areas, we have narrowed down to this road. Now to
Correct.
now to protect this building, my lord, if we are to deviate now, then those will be a fresh round of litigation altogether.
Here, what exercise they have done, my lord, they should place it before the court. Merely because BDA would always act bona fide is not a presumption. ಅದು ತಾವು ನೋಡಿ ತಾವು ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ that's a different issue. But on what exercise they have done, now my lord, at last page,
ಇದಕ್ಕೆ ನಿಮ್ಮ ಆಲ್ಟರ್ನೇಟಿವ್ ಸಜೆಷನ್ ಏನು?
ಅದೇ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಆ ಮೆಮೋದಲ್ಲಿ behind that, my lord, there is a possibility of doing this deviation. Building ಇರೋದೆಲ್ಲ that is our building.
ಫೈನಾನ್ಷಿಯಲ್ ಇಂಪ್ಲಿಕೇಶನ್ ಏನು, ಇಂಜಿನಿಯರಿಂಗ್ ಇಂಪ್ಲಿಕೇಶನ್ ಏನು?
ಅದೇ ಅದು
ಆ ಅಮೌಂಟ್ ನೀವು ಕೊಡ್ತೀರಾ?
ಇಂಜಿನಿಯರಿಂಗ್ ಇಂಪ್ಲಿಕೇಶನ್ ಇಸ್
ನಮ್ಗೆ
ಲಾರ್ಜ್ ಹಿಯರ್.
ಅಲ್ಲ ಬೈಪಾಸ್ ರೋಡ್ ಇಸ್ ಪಾಸಿಬಲ್. ಇದರಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಇವ್ರು ಒಂದು bypass ಕೇಳ್ತಾರೆ, ನಾಳೆ
ಇಲ್ಲ, ಇಲ್ಲ,
ಇನ್ನೊಂದು
ಇಲ್ಲ,
bypass
ಇಲ್ಲ.
ಹಾಕ್ತಾರೆ.
ಎಲ್ಲ bypass ಆಗ್ಬಿಡುತ್ತೆ.
My lord,
Where
we have
possible
produced the
to-
layout map, my lord, to ask that we have to divide the road to protect his building. That's a fair, that's from coming from the petition, my lord, it is understandable. Now, my lord, if one has to be accepted, every other 200 odd structures ought to be protected.
No. How many structures are there? Where they-
Compensation definitely you'll get.
The
And
compensation say
even
they
for
are-
the structures, there is,
ಅಲ್ಲ, ಇಲ್ಲಿ
committee has
ಅವ್ರು
recommended same thing.
family is residing there. It is there. Families are
ಅದಕ್ಕೆ
residing.
3 months ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಮಂತ್ ಎಕ್ಸ್ಟ್ರಾ.
Extra ಕೊಡ್ಲಿಕ್ಕೆ
ಅಲ್ಲ,
ಇದ್ರಾಗ
3 months ಅಷ್ಟೇ, ಬೇರೆಯವ್ರಿಗೆಲ್ಲ 3 months ಕೊಡಿ.
ಬೇರೆ ಸಮಸ್ಯೆ.
ಅಲ್ಲ 3 months ಅಲ್ಲಿ ಎಲ್ಲೋ ಹೋಗಾತು ಬೇರೆ
ಹೌದು,
ಮನೆ
ಬಿಡ್ಕೋಬೇಕು.
Compensation you'll
ಅಲ್ಲ
get.
ಇದರಲ್ಲಿ what exercise they have done not to carry this bypass on this side, my lord, what is the difficulty is not placed before the
Sir,
court.
that is the engineering they have done to draw the roads, acquiring 45 acres only for the purpose of formation of road. Now, if we say deviate in one case, say they can take a bypass in one case, 200
Precedent for
structures
others.
becomes everybody will come
Everybody will
bypass.
start, it will be opening up the floodgates of
Now,
litigation.
when we, there, and next argument is that when we bypass, there are certain other structures who will be affected.
ಅಲ್ಲ ಅದು ಎಲ್ಲಿದೆ?
Because we-
This is on a basis of just saying before the court. No.
So we passed a specific notification was issued for acquisition of road purpose only. That was upheld by the Supreme Court. Thereafter, my lord, this exercise was undertaken. Now to say that, my lord, they have to revisit whether acquisition
In
proper or
fact,
not.
they have passed a resolution that wherever it is possible, bypass can be done at page 9. ಬಡಾವಣೆ ನಕ್ಷೆದಲ್ಲಿ ಅದರಂತೆ ಇದರಲ್ಲಿ ವಿಸ್ತರಣೆ ಮಾಡಲು ಸಾಧ್ಯವಾದ ಕಡೆ bypass ಮಾಡಿದ್ದಾರೆ ಬೇರೆ ಕಡೆ. ಕೆಲವು ಕಡೆ ಮಾಡಿದ್ದಾರೆ, ಕೆಲವು ಕಡೆ ಮಾಡಿಲ್ಲ.
ಸರ್, ಅಲ್ಲಿ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, ಒಂದು ಸಾರಿ ನಾವು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ, ಇಲ್ಲಿ ಕೆಲವು ಕಡೆ ನೀವು ಬೈಪಾಸ್ ಅನ್ನು ಈ ರೀತಿ ಮಾಡಿಕೊಂಡ್ರಿ, ಇಲ್ಲಿಯೂ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ, ಅಲ್ಲಿರೋರು ಕೇಸ್ ಹಾಕ್ತಾರೆ. ಮೊದ್ಲಿರ್ಲಿಲ್ಲ, ಈಗ ಇದನ್ನ ಮಾಡಿದಾರ ಅವರು ಅಂತ. ನಂಬರ್ 1. ನಂಬರ್ 2, ಎನಿ ಬೈಪಾಸ್ ವಿಲ್ ಡ್ರಿಲ್ ಹೋಲ್ ಇನ್ ಟು ದಿ ಪಾಕೆಟ್ of the BDA, and eventually the pocket of the allottees would be hold.
ಅಲ್ಲ
ಅದು ನಮ್ಮ ಉದ್ದೇಶ
Sir.
ಆಗಲ್ಲ.
what exercise they have done, my lord, what I would
True,
do.
now ಈಗ ತಾವ್ ಹೇಳ್ತಿರೋದು bypass it has a cascading effect.
Cascading effect ಇದೆ.
It goes on to the next person, goes on to the next person. Cascading effect will result in catastrophe.
ಒಂದು
ಅಲ್ಲ ಇದರಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ
ನಮ್ಮ ಎಕ್ಸ್ಪರ್ಟೀಸ್ ಏನು, ಎಲ್ಲಿ ರೋಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿಕ್ಕೆ ನಾವು ಇಬ್ರು ಇಂಜಿನಿಯರಿಂಗ್ ಗ್ರಾಜುಯೇಟ್ಸ್ ಅಲ್ಲ, ನೀವ್ಯಾರು ಅಲ್ಲ, perhaps ಇವರೊಬ್ರು ಇಂಜಿನಿಯರಿಂಗ್ ಇರ್ಬೋದು. But how we can infuse our
ಶಿವಪ್ರಸಾದ್ is an engineering.
engineer. Therefore I said, now after joining law, he has forgot perhaps engineering.
More lucrative is.
Engineering law.
ಅವ್ರು ಇರ್ಬೋದು.
ಅಲ್ಲಿ ಅದ್ ಮಾಡೋದು ಸ್ವಲ್ಪ ನಾವು we have to retain the nature of our functions intact, subject to exceptions. Now we cannot run a race
But
of
one
opinions
limited,
with the executive.
one limited prayer which I can make, subject to what your lordship says, is what exercise they have done, your lordship may kindly examine it. If possible, do it. Otherwise,
ಅದನ್ನು
or
observe ಮಾಡಿದ್ರು.
that at least that scrutiny can be done. What exercise they have done? Have they done that exercise?
If we have to assess what exercise they have done on an engineering
Yes.
parlance, we do not have the wherewithal.
No, have they done it at all? that
Without
we
doing
don't know.
that,
At least
roads are drawn.
Let them place that material, at least with that, where road should go, my lord, does not require such kind of, lawyers are supposed to know everything.
ಅದು
And
ನೀವು
judges and lawyers,
ನಮ್ಗಲ್ಲ.
alla, judges and lawyers are supposed to. ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ ಇದೆಲ್ಲ ಬಿಲ್ಡಿಂಗ್
We-
involves lot of heart burn is only.
Lawyers who want to become judge, if at all they are cursed that way, they have to suffer the curse is another thing. But if they know law, that's welcome. But if they know law minister, helpful. This is what people used to say when we were at the bar.
There was some saying, my lord, by an old law book where they say, my criteria for appointing a judge, if he is a good man, if you know something about law, it is all the more better. He should be a good man. Ultimately, we are in a process of learning every day, my lord. Learning will not,
That's how it is. Life
It
we
is-
cannot say.
That is cradle to the grave, learning.
Huh?
ಅದು
ಆ ರೆಗ್ಯುಲೈಸ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಾಕೋದಾದ್ರೆ ಈಗ ನಮ್ದು ಹೋಗುತ್ತೆ ಇದ್ರೆ ಅವ್ರ ರೆಗ್ಯುಲರೈಸ್ ಆದ ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಾಕ್ಬೇಕು ಅವ್ರು.
ಇಲ್ಲ, ಈಗ ಕಮಿಟಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಒಂದು
ಒಂದು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ ಬಿಟ್ವೀನ್ ಆಲ್ ದಿ ಬಿಲ್ಡಿಂಗ್ಸ್, ಮತ್ತೆ ಇಟ್ ಕಮ್ಸ್ ಇನ್ ದ ಮಿಡಲ್.
that is where the road passes by.
Please.
nobody, even enemies will not be happy to demolish any structure. This is our presumption. BDA is not on its feet and toes to demolish what is constructed. But wherever possible, reasonable effort should be made to retain the structures as they are, is your worship. That's all.
No, only one question is, I mean, I cannot question, but one point which for
No,
clarification.
you are entitled. We are not unquestionable. We are not Mughals.
No,
We are
there
all-
will add, what happens to the building which is in between, which is regularized? ಅದನ್ನು ಡಿಮಾಲಿಷ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತಾನೆ.
ಹೌದು.
ಅದಕ್ಕೆ compensation land building value also will be fixed by the.
But committee's decision will have to be overruled.
ಹೌದು.
Ah.
Inevitable ಆಗ್ತದೆ. Committee decision, committee is not
The committee itself says how it should be resolved. Page 43,
Number 2,
Rohan
page
ಹಾಕಿದೆ.
43, Rohan ಕೊಟ್ಟಿದ್ನಲ್ಲಿ. Rohan
ಅದರಲ್ಲಿ
has produced that.
what is to be done ಅಂತ it's clearly said. Committee itself says.
Because at the time of regularization, my lord, the layout plan is not with the committee. It's only what is the factual aspect which the petitioner or the applicant presents. On that decision
So,
will be taken.
see,
Thereafter, my lord, it will be integrated onto the layout plan.
Now the committee in contemplation of such cases
Yes.
has drawn this procedure.
Well, otherwise also. Impossible. Yes, yes, of
Cases
course.
coming up.
Rohan-
But even otherwise also. yes.
Even otherwise.
Yes, in fact, on the 30th
You
report,
can't
my lord, they
expect-
say,
We can't ask the BDA to do the impossible. These things in formation of layout, magic will not work. The pragmatics do. We cannot do layout, we cannot develop layouts by magic. Something, somebody will be affected, somebody loses the land, somebody gets compensation belatedly. These are inevitables of any development. Any development. That happens, but that should be minimized. With fairness and other things, we have to operate. ಅದನ್ನ ಬಿಟ್ಕೊಂಡ್ರೆ
Since
there
we
is
are,
nothing,
since, my lord, the parties are residing there and they are required to vacate. And
Correct.
normally, since we know, my lord, how BDA functions, it could take years and years to give us the alternate land also.
We can.
no, they'll also
That-
be one of the first land losers. My lord. They will put,
Exactly.
they can be
That-
first
ಅದನ್ನು
category of land
ಏನಾದ್ರು
loser.
ಒಂದು time ಅಲ್ಲಿ
ಯಾರು ಲ್ಯಾಂಡ್ ಲೂಸ್, because in one judgment.
Because they are a land loser.
ಯಾರ್ಯಾರು ಲ್ಯಾಂಡ್ ಲೂಸ್ ಮಾಡಿದಾರ ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟು ಆಮೇಲೆ ಅದನ್ನ
Yes, but that's what
ಮುಂದಿಂದೆಲ್ಲ
even-
What I would
Also
request
held.
is, my lord,
Ah.
I mean, subject to what the court would say, that is, once they give the land, we will kindly permit us to vacate this building. ಅಲ್ಲ ಅವ್ರು ಕೊಡೋದೇ ಇಲ್ಲ, ಅವರು ಲ್ಯಾಂಡ್ ಕೊಟ್ಟರೆ
that we can put on terms. ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ,
That we can put on
ಮತ್ತೆ ಕೋರ್ಟ್ಗೆ
terms.
ಬರ್ಬೇಕಾದ
ಕೊಡೋವರೆಗೂ ಅವ್ರಿಗೆ ಬಿಡೋದೇ ಇಲ್ಲ.
They'll say that my house was here, they have given me some places. We'll try to accommodate them as near to
ಅದು
as
ಬಿಡಿ,
the-
ಆ
But-
ಪ್ರಪೋಸಿಷನ್
yes.
ಒಪ್ಕೊಂಡ್ಬಿಟ್ರೆ ಲೇಔಟ್ ಇನ್ನೊಂದು 20 ವರ್ಷ ಆಗಲ್ಲ. ನಮಗ್ ಬಹಳ ಫಾಸ್ಟ್ ಆಗಿ ಲೇಔಟ್ ಮಾಡಿ ಜನರು ಕಾಯ್ತಾ ಇದ್ದಾರೆ. ಆ ಕಾರಣಕ್ಕೆ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ, ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟೆಡ್.
ಅಲ್ಲ ಇದಕ್ಕೆ ಹಾಗಾದ್ರೆ ಲೂಸಿಂಗ್ ದ ಲ್ಯಾಂಡ್, ಲೆಟ್ ಅಸ್ ಸೇ, my lord, your lordship says that I should vacate in 3 or 4 months or whatever. Court says. The equivalent extent of land he is losing should be given to him as close as possible.
43-2.
But,
ಅಲ್ಲ,
Page
page
43.
43.
43-2 is what I am reading. ಅದಕ್ಕೆ when that will be done ಅಂತ ಅಷ್ಟಕ್ಕೋದು, that at least that extent we may be safeguarded, because BDA, my lord, will take their own time even to do this. ನಾವು 3 ತಿಂಗಳಲ್ಲಿ ಖಾಲಿ ಮಾಡಿ ಹೋಗ್ಬೇಕು. Then this aspect, my lord, will take its own time.
Leslie.
ಅಲ್ಲಿ ಇದೆಯಲ್ಲ equivalent extent or the road should be done to
ಇದು
the-
ಇದು
to the
ಇದು
existing
ಇದು
property.
ಪ್ರೊಸೆಸ್ ಮುಗಿಬೇಕು. ಅದು ಆಫ್ಶೂಟ್ ಲಿಟಿಗೇಷನ್ಸ್ ಇರ್ತಾವ, ನಮ್ಮೆಲ್ಲ ಹ್ಯಾಂಡಲ್ ಬಿಲ್ಡಿಂಗ್ಸ್.
ಈಗ 3 months
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ
to move
ಕೊಟ್ಟು
out.
ಕೆಲ್ಸ ನಿನ್ 3 months ಜಾಸ್ತಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವ್ರು ಕೇಳಿದ್ರು, ರೋಹನ್ ಆಸ್ಕ್ಡ್ ಫಾರ್ 12 weeks, 6 months.
ಹೇಳಿರೋದು 6 months.
ಅಲ್ಲ, 6 months
You know, because if you ask this much, you will get this much ಅನ್ಕೊಂಡೆಲ್ಲೋ ಒಂದ್ ಕಡೆ inarticulate ಆಗಿ.
ಅಲ್ಲ, ಅವ್ರು 1 ವರ್ಷ ಕೇಳ್ಬೇಕಾಗಿತ್ತು. 6 ತಿಂಗಳು ಕೇಳ್ಕ ಮಧ್ಯದಲ್ಲಿ 4 ತಿಂಗಳು ಕೊಟ್ಬಿಡಿ. 4 ತಿಂಗಳು ಏನ್ ಅದ್ರಲ್ಲಿ ಏನ್ ಮನೆ ಇದೆ, ವಾಸದ ಮನೆ ಇದೆ.
4 months.
ನೀವು ಆಲ್ಟರ್ನೇಟ್ ಇದು ಕೊಡಕ್ಕೇನು?
But so far as
4 months ಕೊಡೋಣ. Provided they to show bona fide.
ಹೌದು.
ಅವರೆಲ್ಲ ಏನೇನು cooperate ಮಾಡೋಕೆ ಅಷ್ಟು cooperate
because
ಮಾಡ್ತಾರೆ.
litigations are still pending.
Clear ಆಗಿದೆ,
We are unable to
ಹೇಳಿ
complete the
ಅವಾಗ
entire layout.
ಯಾಕೆ ತೋರ್ಸ-
Although certain portion of the layout has been completed. To
ಇಲ್ಲ, ಬಟ್ ಅವ್ರಿಗೆ ಆಲ್ಟರ್ನೇಟ್ ಕೊಡಕ್ಕೆ
once the they may
it is complete.
no man.
Then?
Once we start allotting to the land losers, they'll
Ah.
also be treated on par with the
Correct,
land
on
losers,
par
because
with
they're
the
also
land
land losers.
losers and on priority
Because
whatever.
on priority they'll be given. And
ಅದಕ್ಕಾದ್ರೂ time bound ಮಾಡಿ.
and pursuant to Supreme Court's order, first we have to allot it to land losers,
ಹಾ.
then the revenue side.
How long do you take that exercise?
ಅದಕ್ಕೆ ನಮಗೆ ಟೈಮ್ ಲೈನ್ ಕೊಡಿ.
ಈಗ ಅವ್ರಿಗೆ ವೆಕೇಟ್ ಮಾಡಕ್ ಟೈಮ್ ಲೈನ್ ಕೊಡ್ತಾರೆ.
ಕೊಡಿ. ಅದೇ
ನಿಮ್ಗೂ
ರೀತಿ ನಿಮ್ದಕ್ಕೂ ಕೊಡಿ. ಅಲ್ಲಿ ಮತ್ತೆ ಯಾವ್ದಾರ ಒಂದು ಸ್ಟೇ ಬಂತು
ಅದು ಕೇಳ್ಕೊಳ್ಳಿ.
ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್.
After
Huh?
4 months, my lord, they'll seek for vacating the premises.
ಹಾ.
Thereafter 4 months, my lord, we'll.
ಎಲ್ಲಿ ಹೋಗ್ತಾರೆ ಅವರು?
but until the only-
ವೆಕೇಟ್ ಮಾಡಕ್.
vacate
ಕರೆಕ್ಟ್. There after 4 months you will allot.
till we allot the land, because all the land losers have to be accommodated.
ಆಮೇಲೆ ಅದು 4 months ಒಂದೇ ಡೇಟ್ ಕೊಡ್ಬೇಕು. ಒಬ್ರಿಗೊಂದು 4 months ಮಾಡಕ್ ಬರಲ್ಲ ಅದು.
So it's a system.
ಅದು 4 months
ಅಲ್ಲ,
ನಡೆಸ್ತೇವೆ.
No, no.
Because
All
the sites also are of odd dimensions here, because we are forming this layout of 50, 40 site, 40, 60 and 58. Now, my lord, let us assume there's 1,500 square feet. Then we'll have certain changes have to be made. Keeping that in mind, my lord,
ಆಯ್ತು, 4
Yes.
months to all the land losers or few?
no, to
Our-
all the land losers. Yes,
That we will.
yes.
ಒಂದ್ ಕಾಮನ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ ಆಗ್ತದೆ. ನೀವೆಲ್ಲರಿಗೂ ಬಿಟ್ಕೊಂಡು ಒಬ್ಬೊಬ್ರಿಗೆ 4 ತಿಂಗಳು ಬಿಟ್ಕೊತ ಹೋದ್ರೆ 5 ವರ್ಷ ಹಿಡಿತದೆ. ಆರ್ ಲಿಟಲ್ ಮೋರ್ ಆಲ್ಸೋ.
I'm told, my lord, of the land losers, only for 50% of the people, entitlement certificate has been issued pursuant to their land being lost. BDA has issued an entitlement certificate. Some of them are ready to approach the BDA for allotment of that or for receiving that entitlement certificate. Once they receive the entitlement
ನಮ್ದು
certificate,
ರೆಕಾರ್ಡಿಂಗ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಹಾಕೋಣಂತ. ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡೋದು ಆ 4 months ಫ್ರಮ್ ವಿಚ್ ಡೇಟ್ ಅನ್ನೋದು. ಅದು ಯಾವ್ಯಾರು ಬರ್ತಾರಲ್ಲ ಅವ್ರು ಏನೇನ್ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ, 4 months from entitlement certificate. Entitlement for what?
if the land loser, my lord, had lost in 1 acre of land, they are entitled for 9,300 odd square feet.
All right.
Yes,
That certificate is issued by you.
is issued by the BDA to the land loser.
So
Insofar
they
as
would
the
approach you for entitlement certificate
Yes,
that
madam.
they have lost this much. You issue a certificate.
entitlement certificate.
From that date, how much time you want?
ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೂ ಟೈಮ್ ಲೈನ್ ಬೇಕಾಗ್ತದೆ.
ಎಲ್ಲದಕ್ಕೂ time line. ಎಲ್ಲದಕ್ಕೂ time line.
To give a specific date, my lord, I require some time. On the next hearing date, I'll give a timeline. Now, my lord, at least it could be decided that how these land losers will be compensated. The next hearing, my lord, I'll give a specific timeline.
ಆಮೇಲೆ ದಿಸ್ ಸೈಟ್ ಓನರ್ ದೇ ಆರ್ ಆಲ್ ಸ್ಮಾಲ್ ಸೈಟ್ಸ್ 15 to 25.
So-
ಅದಕ್ಕೇನು ಈ ಅಪ್ರಾಕ್ಸಿಮೇಟ್ ಅದೇ ಕೊಡ್ತಾರಾ ಅಥವಾ ಅದನ್ನ ಅರ್ಧ ಮಾಡಿದ್ರೆ ಇನ್ನು ನಮ್ಗೇನು ಸೈಟ್ ಇಲ್ಲ?
ಅಲ್ಲ, land to land ಬರಲ್ಲ.
ಎಲ್ಲ
Land to land.
1,000 ಇದ್ರೆ 1,000.
ಇಟ್ಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ರಿಕಂಪನ್ಸೇ.
Yes. If
It
it's
does not fit into our jurisdiction.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆತರ ಬರ್ದಿದ್ದಾರೆ ಅದು.
ಅದೇ ಬರ್ದಿದ್ದಾರೆ ಅವರು.
ಇಲ್ಲ, we will
But
record
you know,
that.
mandate.
We'll record that.
We can record. We cannot decide that.
because it's a 1,000 square feet plot, we'll have to form a 1,000 square feet plot and give it to them, because all the other amenities also has been
ಅಲ್ಲ,
fixed.
ಅಂತಲ್ಲಿ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, this is what VG Ramachandran says on land acquisition, law of land acquisition. Compensation for the structure also. ಅಲ್ಲಿ ಅದಕ್ಕೆ ನೀವು ಆ ರೇಷಿಯೋ ಮಾಡುವಾಗ ಹೆಂಗ್ ವರ್ಕೌಟ್ ಮಾಡ್ತೀರಿ? Is it on the basis of structure or basis of dimension of the site on which structure is put
No,
up?
no, this,
ಅದ್ರ ಮೇಲೆ
these cases,
clarity ಹೇಳಿ.
these cases are different, because building also has to be separately compensated. Land also ought to be separately compensated.
ಅಲ್ಲ,
So far as land is concerned, as a 1,000 square feet plot, we'll be giving a 1,000 square
Land
feet
to
plot.
land ratio ಅಂದಾಗ dimension of the site.
Dimension to dimension. If it's a 1,000 square feet, 1,000 square feet.
Dimension.
Now,
The
my
land
lord-
to land dimension.
Clear.
Now, my lord, there are certain structures which have come up on 1,000 square feet plot for 4 or 5 floors. Illegally constructed. Now, to seek
No, no,
compensation for that illegally constructed portion may not be correct. Because-
ಇದು
Court order.
Illegally
that-
ಅಂದ್ರೆ
that-
ಮುನ್ಸಿಪಲ್
that
ಲಾದಲ್ಲಿ
generate-
illegally ಅದು. Illegally constructed structures compensation ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ, not for the entire illegal structure. Some amount of compensation will be given. But to say that, my lord, it should not fair with so far as legally constructed building and illegal construction should be treated on the same par, that may not be right. Because there are certain illegal structures have not been regularized by the committee.
ಹಾಗಾದ್ರೆ ಒಂದು ರೀತಿ ನಾವ್ ಹೇಳೋಲ್ಲ ಅದು.
See,
They
if you
should
say
become
somebody's
part of the
illegal
court order.
structure, he will get it regularized. ಆಮೇಲೆ if the structure is left off,
ಇದು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
it is open to anybody to get it regularized, litigation or whatever it is. You can't say brush it aside saying it is illegal structure, will not compensate.
Because there are certain illegal structures not regularized by the committee.
who will decide the structure is legal or not?
They have to produce the plan sanction, appropriate authorities, whether they have permitted them to construct certain number of floors. That is because
how
that road is passing through that structure.
how courts have answered this question? If structures are put up in violation of the building bylaws, whether value of such structure should be the basis for compensation or not? How this is answered by the courts?
That's why I read the order. All constructions ought to be safe.
All constructions are
Restrict-
All kinds of
restitution.
lawfully built.
Restitution. Yes, not saving.
There are several
Saving
such-
is not restitution.
Correct.
Yes.
Prior to the cutoff date itself. But for
Cutoff
example,
date ಏನು?
Now, we are asking you, suppose prior to the cutoff date, you will put up construction up to the heaven. You mean to say BDA should compensate for entire structure, even when it is blatantly illegally
But
put?
while awarding compensation, legality or illegality of the
Not
building
the
is
law.
not a consideration.
How courts have answered this
That
question?
my lord I'll have to see, but they are expected to value Land Acquisition Act ಕೂಡ Land Acquisition Act ಇದೆಯಾ? ಅಲ್ಲ ಓಲ್ಡ್ ಆಕ್ಟ್ 24 ಇದೆಯಲ್ಲ ಕೊಡೋದು.
Restitution ಅಷ್ಟೇ.
ನ್ಯೂ ಆಕ್ಟ್ ಅಲ್ಲಿ ಏನಂತಿದೆ?
How jurists have answered this question, or
In
Mr.
fact,
Rao, how courts have answered this question? If structures are put in violation of law, whether value of those structures also should be the criteria for determining the
To
compensation
the
or not?
extent of, I'll produce a case law on that, to the extent it has to be a restitution and recompensation. Because the illegality in the construction
which is the
it
problem?
cannot be, because for that matter, the Gurgaon case,
The construction is
Not 24, take 20 earlier probably.
Twin Towers in Delhi, where the.
It was brought down.
It was brought down.
It was raised to the
But
ground.
when it-
Raised to the
See,
ground.
when it came to that, the insofar as the allowing the landowners to utilize the land for a different purpose, because
Yes.
it was put in a
That's for a
private.
park.
For
Yes.
for a park. I am just drawing a near analogy for that. It may not be an accurate.
No, this is not, this cannot be like that. This question is answered by the courts, not that for the first time in this court, the question has arisen.
If it comes
has
to fair
arisen.
compensation, my lords, if it, under the new act, if it comes to fair compensation,
This is
metro,
old
for
act or
example,
new
we'll
act?
take a BMRCL
Huh?
project. BMRCL is implementing,
Old
under the
act.
KADB is implementing the project.
Not
No,
that
no, no.
question at all. Our
Lordship's question
so
is,
specific.
Yes.
Exactly, fifth floor construction.
illegal structures are also entitled to compensation.
Not.
na? Anta is lordship's
Because
question.
once
that
we
should-
say
What are the factors to be?
we placing premium on illegality,
Yes,
this aspect is also.
What are the,
How courts have
that we
considered.
what
to
are the
reward for the
factors to
illegality.
be borne in mind while awarding compensation is specified under the old act?
23,
Section 23 and 24.
23.
23 and 24. 24 deals with what are the facts to be neglected.
This
But it
question.
does not specify this act, this aspect.
No, there are judgments on that. There are judgments. Ah.
Been a situation where my property was not going for the road, then it would have been regularized by the committee.
Well, regulation is also subject to limitations.
Precisely.
That is, only that much they can consider.
Therefore, having regularized several structures solely on the basis of the cutoff date.
Admit regularization.
Are regularizable in a manner known to law. Those will be subject to compensation.
Dealing is there, they cannot demolish ಅಂತ ಮತ್ತೊಂದು ಇನ್ನೊಂದು aspect. This is true. Several aspects.
May I make just one request? Since the BDA is well aware as to what are the constructions which are going and what are the constructions are not going, they may itself place a report as to what are the constructions which are going.
We are not on factuals at all. We are on a proposition of law, but none of you is, the views of none of you are throwing light on that proposition.
Anyhow, BD also has not thrown light saying that we are not entitled to.
No, they want to remove the light now. Arguably.
But
From your
now
side.
this
Asking the
issue may
BDA
have to
to-
be.
Asking the BDA to pay compensation to the illegal structure, my lord, that will be
No, what is the prohibition? Now kindly see 23, 24.
for an illegality.
No
my lord, we
question
are
of
paying a price for
legality or
that.
illegality.
Ah,
Market value as on the
More
date.
particularly
No
for the
such-
regularization scheme.
If that is so, Lord, in every building there will be deviation.
A Supreme Court order in this 3/8/2018 ಆದ್ಮೇಲೆ Supreme Court said structures are to be saved
Yes.
in accordance with
In
law.
accordance with law,
The
yes, yes.
structures
Saving.
that have come up in accordance
Yes,
with
yes.
law, the 3/8/2018
Please.
order, if you see,
Yes,
it is clear that structures which have come up in accordance with law
Yes.
and permission being
Permissions have been
granted
obtained,
by the
yes.
authorities, only those will be saved is what is.
yes.
Saved.
Now, my lord,
We will
adjacent-
draw the
yes,
same analogy to
because
this
if an
also.
adjacent homeowner has put up 2 floors
that-
and an illegally constructed neighbor has put up 4 floors, he gets an higher compensation. Even though both are passing through the road.
the license.
The 3/8/2018
analogy-
order, Supreme Court.
That analogy, my lord, may be relevant only for saving the structure. But if it is a question of determining
No,
the
that is why-
valuation,
Can't we paraphrase that to the compensation part of
no,
it?
my lord.
What?
No, it can't be done because insofar as the way in which compensation will have to be determined is there in the act itself. Now, saving is a different issue because land is acquired, it has to be saved. In what manner I am entitled for compensation is provided under the act. The act does not say that if it is legal or illegal, then it will have to be, you are not entitled for compensation. It's not there. So long as there is no
Kindly-
prohibition.
The order of the Supreme Court, I'll read, as stated
Okay.
above, the buildings constructed in the layout with valid sanction/permission from competent authority needs to be
That's what.
That is to be saved.
Therefore-
So,
yes, therefore it is important to identify.
Sir, we can definitely draw unless we.
Lord, that would be very highly unjust, my lord. In a case where I have completed the construction and panchayat license is also there, suppose let us say I put 1 floor, my lord, without there being a plan. I may have a remedy elsewhere. I may seek for regularization under that act to say that all these are illegal buildings, I will not give compensation, my
Right.
lord, is not justified.
Is why the buildings that are regularizable in a manner known to law
ಅದಕ್ಕೆ
can
ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
become subject matter of.
No, my lord,
compensation.
with great respect, it is my submission that whether
Sir,
legal
one-
or
one
illegal,
moment.
I'll point out.
If a particular cital area has permission to put up 1+2 and you put up 1+4, is that
Unless-
not illegal?
I know, my lord. Then also I am entitled for
Honest.
compensation.
That will.
Entitled for
that will-
compensation
On the-
because
On the
basis of
assumption that section 23 does not exclude them ಅನ್ನೋದು ನಿಮ್ಮ position.
my submission, whatever is the market value of the property
Courts
that
have-
is acquired.
How courts have
I understand.
in the High
I did
Court,
not anticipate this question. I'll get ready and
You
answer.
have to
that.
get.
But so far as the issue, my lord, with regard to this, some of them, my lord, have been, the license is obtained 2 days thereafter. Now, if they say it can't be regularized, that issue will have to be decided here because otherwise we will be left in lurch. Unless they say, in case of all these buildings, it will be regularized. Then they will once again reject, then we'll back to square one.
Fact. So these cases, the award notice, buildings have already been valued.
ಅವ್ರು they might have valued. Question is when we have to pay
Therefore-
for that, this question arises.
When it's
ಅವ್ರು
having valued,
ಅದ್ನ ಮಾಡ್ಬೇಕೋ ಬೇಡ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗ್ತದೆ. ಅದರ ಹಿಂಗೆ ಬಿಟ್ರೆ ನಾಳೆ they may deny to you or tomorrow you may claim compensation. We do not know because we have not yet decided that issue. What they have valued is irrelevant. Some FDC will do that.
they have valued it, they were ready to pay so much, they've deposited that compensation, whether it is unlawful or lawful.
That
Now
we
it is
have
not
to
open
decide.
for them to
No,
take up
it
that
is
risk.
open to us to decide.
Certainly, but what I'm really trying to point out is that these persons, had it not been for the road,
ಮಾಡಿದ್ದಾರೆ.
This will have to be decided.
Committee, it is not committee's words are gospel. We have to interpret, they might have accepted. We have to otherwise tomorrow that would be, that may be arguable. We do not know. There are, there both the points are very, we are oscillating, in fact. Because we have to see so many other factors also. It should not be construed or run the risk of being construed as placing premium on illegality. That is one general principle.
Supreme Court has answered this question. Even
How?
though
How?
I will get the full judgment.
Buddy.
Since I got it quickly, I am saying.
Read.
The High Court has ruled that the state is not obligated to pay compensation for buildings constructed without authorization. In a notable case, it was held that since the construction was unauthorized and the owner had knowledge of the acquisition, the state is not bound to compensate for such structure.
That is
High Court's
after.
direction to pay compensation was deemed illegal. State of Orissa versus Raj Kishore Das, Supreme Court Executive Officer. I'm getting it.
That is a case, owner
I'm
has
just assisting the honorable
put up
court.
construct.
We appreciate you.
ಅಲ್ಲಲ್ಲ, ವಿರುದ್ಧವಾಗಲ್ಲ.
We appreciate that.
That, no, that
No,
is
you are
why-
there to.
No,
tell
no,
what is
this
the law.
position says, this position says knowledge of acquisition, he has put up the construction.
That is correct. If the.
No, no,
if-
here,
if
my lord.
legality is 1+2 in an area, if you have put up
But
4.
it is
you are
not a legal, it is not a
construction.
legal proposition.
One more aspect.
Will run the risk
You
of. it
cannot be benefited by ignorance of law. If
no.
you do not know
We are
law,
not
when,
seeking,
at least to the extent it affects your business, you are bound to know law.
no, we are not pleading ignorance of law. But the point here is, when you are acquiring the property, you have to pay market value on assessing the market value only. No question of saying the ignoring some of it, saying that this is not legal, this is illegal. But subject to correction. BDA itself has not taken that stand in any case.
It's all right. But
In any case, BDA does not say, no, this is illegal building, this is that.
Because
Subject
it-
to correction.
Pursuant to Supreme Court's order, we are bound to follow.
No, not in this
Because-
case. Nowhere in the
No,
land acquisition
Supreme Court
proceedings.
says.
Supreme Court
Lawful
says,
constructions ought to be protected.
Supreme Court says in the background of saving certain
Saving,
buildings.
correct. Saving.
No, the same analogy will not apply in a case where the determination of compensation. Determination of compensation is an independent process. That issue, my lord, your lordship may decide.
Will decide.
And another thing is, now if everything is left to them, my lord, then one way or the other, we should know where we stand. Now, some of these licenses have been given 2 days, 3 days after the cutoff date. What should happen to us also, my lord? It should, otherwise they will once again reject it, saying that you are not entitled to.
So the cutoff date was fixed by the Supreme Court.
proximity, but
Correct, that is not with regard to compensation.
support. ಕೊಟ್ಟಿಲ್ಲ ತಗೊಳ್ಳಿಕ್ ಬರ್ತದೆ ತಗೊಂಡಿಲ್ಲ ಅವಾಗ ನಾವು ಒಂದು ನಾರ್ಮಲ್ ಮಾಡ್ಬೋದು ಸಪೋಸ್ ರೆಗ್ಯುಲರೈಸ್ ಬಲ್ ಇದೆ
Everything.
ರೆಗ್ಯುಲರೈಸ್ಡ್ ಬಲ್ ಯಾರು ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಎಲ್ಲ ಸರಿ
780 ತಗೊಂಡಿ ಹಾಗೆ ಅದನ್ನ ನೀವು ಆಮೇಲೆ ಕೊಡಲ್ಲ ಅನ್ನೋದಾದ್ರೆ ಇವೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತೀರಾ ಅಂದ್ರೆ
ಅದು ಇದನ್ನ ಬಿಹಾರ್ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ ಪಟ್ನಾ ಹೈಕೋರ್ಟ್
Orissa,
ಜಜ್ಮೆಂಟ್ ಮಿಸ್ಟರ್ ರಾವ್ ವೆರಿ ಫೇರ್ಲಿ ಸೆಡ್ ದಟ್
ಎಲ್ಲಿ ತೆಗೆದ್ರಲ್ಲ ಈಗ
Raj Kishore Das.
ನೋಡಿ ಬರ್ಕೊಂಡದ್ನ
ಅಲ್ಲ ಈಗ ಇಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ರು ಇವರು ಈಗ ನೋಡ್ತಾ ಇದ್ರಲ್ಲ ತೆಗೀರಿ.
ಇದೆ. You careful. No, it was.
ಅದಾ? ರಾಜ್ ಕಿಶೋರ್ ಅಲ್ಲ ಬೇರೆ.
iPad and assistant. It will just take 5 minutes. My colleague is pulling it out from the end.
ನಿಮ್ ರೈಟ್ ಅಪ್ ಅದ್ರ ಮೇಲೆ ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ ನಾವು ಇಲ್ಲ we have heard and we have reserved, we will do our research also.
No,
ಅಲ್ಲಿ
I'll be
ಫೈನಲ್
able to
ಆಸ್ಪೆಕ್ಟ್ಸ್
take
ಎಲ್ಲ
some
ಇದೆ.
Recommendation to the committee, even with respect to unlawful structures, have been accepted by the honorable Supreme Court. Even in some of the cases which I have heard.
No, we'll see. It's not say that. We'll look into it only and then because this will have a wide reaching
Wide range of
ramification.
Lord, that aspect your lordship may hear that issue, my lord. Because ನೀವು ರಿಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರೆ ಒಂದಿನ ಹಿಯರ್ ಮಾಡಿದ್ರು ಒಳ್ಳೆ.
ಹೌದು.
Lord, that other issue is in my table, some of them Lord, license is given 2 days after the cutoff
that
date.
also
ಅದು ಒಂದ್ ಸ್ವಲ್ಪ ಅದರ್ವೈಸ್ ಈಗ
able. Which will fit into
Regularizable.
regularizable. Licensability is sufficient. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ತುಂಬಾ ಅನ್ಯಾಯ ಆಗ್ಬಿಡುತ್ತೆ.
Let's see, it needs,
ಅಲ್ಲಿ ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಅಂದ್ರೆ ವೆದರ್ ಎಕ್ಸ್ಪೋಸ್ಟ್ ಫ್ಯಾಕ್ಟರ್ ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ ಬಿ ಗ್ರಾಂಟೆಡ್.
ಅದು ಏನಿಲ್ಲ,
ಒಂದು
3-4 days, my lord, even before they could know.
in your case 3, other person will come. You have given 3 days for Mr. Harnalli. Mine is 4. Give it. It goes like that.
ಅದೇ ಸೇಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್
it
ಮೈ
may-
learned friend is making. ಇಲ್ಲಿ ಕಮಿಟಿ ಅವರೆಲ್ಲ ಅನಾಥರೈಸ್ ಬಿಲ್ಡಿಂಗ್ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ವೈ ನಾಟ್ ಅವರ್ಸ್ ಇಸ್ ಹಿಸ್ ಪಾಯಿಂಟ್.
ಅದ್ರ ಮೇಲೆ ಒಂದು ಲಾ ಡಿಕ್ಲೇರ್ ಮಾಡಿ.
Just a couple of more points that I'm adding to that. One is so far as this entitlement certificate. That also may be issued to the bank.
no, that is, see, for everything, cutoff date and things like that, certificate issue ಮಾಡೋದು that will do. But this aspect we will hear you once more.
Here ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
So far as the
We'll do one thing. On Wednesday, we will post this matter, only for this purpose,
Only this.
at 3:30 PM. In 1 hour's time, all of you should come.
ಬರ್ಬೇಕು. ಆಮೇಲೆ ರಿಪಿಟೇಷನ್ ಮಾಡಂಗಿಲ್ಲ. ಒಬ್ರು ಹೇಳಿದ್ಮೇಲೆ ಮುಗಿದೋತ್ ಮತ್ತದು ಅದಕ್ಕೆ ಬೇಕಾದ್ರೆ ಆಡ್ ಮಾಡ್ಬೋದು. ನಂತರ ಯು ಹ್ಯಾವ್ ಟು ಬ್ರಿಂಗ್ ಯುವರ್ ನೋಟ್ ಶೀಟ್ ತೊಗೊಂಬರ್ಬೇಕು. Not
All
currency
these
note.
matters will repeat on that day.
ಒಂದ್ ನೋಟ್ ಮಾಡ್ಕೊಂಬರ್ಬೇಕು. ನೀವೇನ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿರಲ್ಲ ಅಲ್ಲಿ ನಮ್ಗೆ ನೆಬುಲಮ್ ಅನ್ಸ್ಬಾರ್ದು. ಎಸ್, ದಿಸ್ ಇಸ್ ದಿ ಕ್ವಶನ್, ದಿಸ್ ಇಸ್ ಅವರ್ ಆನ್ಸರ್, ದಿಸ್ ಆನ್ಸರ್ ಈಸ್ ಸಪೋರ್ಟೆಡ್ ಬೈ ದಿಸ್ ಸೆಟ್ ಆಫ್ ಡಿಸಿಷನ್ಸ್ ಬೋತ್ ಮಾಡ್ಕೊಂಬ. ಅವ ಟೈಮ್ ಸೇವ್ ಆಗ್ತದೆ. ಎಂಡ್ಲೆಸ್ಲಿ ನೀವು ಬೇರೆ ಇದ್ರಾಗ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತದೆ, ಲೇಔಟ್ ಬರೋದೇ ಇಲ್ಲ.
ಅದಕ್ಕೆ ನೀವು ಏನ್ ಹೇಳಿದ್ರು ನೆಬ್ಯುಲಸ್ ಇರಬಾರ್ದು.
ಇರ್ಬಾರ್ದು. ನಿಮ್ ರೈಟ್ ಅಪ್ ತೊಗೊಂಬಂದ್ಬಿಡಿ. ನಿಮ್ ರೈಟ್ ಅಪ್ ಏನಿದೆ ತೊಗೊಂಬಂದ್ಬಿಡಿ. ವಿಲ್ ಬಿ ಏಬಲ್ ಟು understand.
May I seek my lord's indulgence in making one specific submission without involving repetition for the day? While I will make my detailed submissions on Wednesday. Now, in the instant case where I am appearing in 6.3 and 6.5, we are not under an acquisition. The moment the regularization certificate came to be issued by BD after thorough deliberation, it has gone out of the acquisition. Now, we are not part of any second notification or anything. And in that regularization, what we are seeking is that the possibility, in fact, in one of the hearings of 3 months back, it fell from the mouth of the honorable court that the BDA to consider the balancing act in such a way that they go near to the restitution. May not be the exact restitution. I am not putting for.
Even today, we have said that.
So the restitution,
today.
according to me, in my case, the restitution is that the BD having issued a regularization certificate, as per the regularization certificate, I'm adverting the existing road. I'm not talking about forming of the new road. I'm not making any submission on the new. In fact, the sketch is placed on record, which I will do. Now, the difficulty which arises is that the landowner who has lost all his land, except.
Question is, we are again telling you, there is some sense in which you are saying, we understand.
I'm obliged.
But point is, the pragmatics in the formation of layouts, the economic pragmatic, fiscal pragmatics, engineering pragmatics, they should drive the decision.
My lord, the
With
citizen.
fairness, with
Yes,
fairness.
the citizen may have to be convinced, the litigant citizen may have to be convinced that in all fairness, what
They
BDA
have
has
done that impression, the BDA. has to do.
BDA has to.
Agree.
And another alternative submission without prejudice is that while it has been deliberated and it has transpired, now if a 80-feet road gets widened to 120 feet on one side, the factual matrix is that not on both sides. In the instant case, the petitioner's case, the BDA chooses that we will widen the road only on one side. Leave these structures which are full-fledged structures which are there on, if I were to just give the example I am passing through.
No, if the engineering is that way for the
That
purpose of
way.
formation
It
of
is maybe
road.
permissible.
Now, if we say this structure should not be left off and this structure should be kept.
These are all engineering
No.
aspects.
No,
Like,
we
yes,
cannot say, no, this structure, this is not correct, road should go like this.
No, my lord, the road alignment will not change in this process, except that it gets sliced with the both side owners will lose half.
That alone is not the justice point. Many other aspects.
Another alternative, if that this is not acceptable, there are two alternatives which I am suggesting to the honorable court, subject to what BDA is going to say. One is that our experience is that a revenue side loser, as per Junjama in 2005, even today they have not obtained an alternative site. Several reasons are there, but the honorable court is keeping that in mind while mounting the relief. I am not going to elaborate on that. Just to fortify my submission, I am saying that would it be possible for the honorable court to consider directing BDA to draw up a scheme if required as an amicus
Not
curiae?
at the, sir, much water has flown with all that. Now we can't put the clock back
No,
to the
no putting
scheme,
the clock
nothing.
back. No putting the clock
Yes.
back, my lord. I am not suggesting for putting the clock back. If required, as whatever a little we know a law, we will assist the BDA as amicus curiae. And a time
On-
limit of 2 weeks or 3 weeks may be specified. And the ultimate effort is that please give us an.
No, we can't evolve a scheme here as to how to do it. We will have to pass orders in accordance with law, what the apex court has said,
At
committee
least
has said,
order.
and all that.
Yes, my lord. I'm
Now, the way, we have to evolve a scheme saying that you slice this house, you slice that house on the other day.
No, at a narrow level, I'm saying.
Anything short of we becoming super BDA will entertain the argument.
Yes.
I'm
Do not
obliged.
reduce it or do not elevate it to the level of
Yes,
BDA.
my lord. Yes, my lord. Now last submission, within a minute I will close. The petitioner who is located just abutting the existing road,
All right.
he loses the structures which have been regularized by the committee.
Hmm.
And now BDA has not taken any action to nullify that regularization. They are on the defense, they are not on the fence. They have not given me any notice that this is required.
That they will do. See,
So-
ultimately, if road passes through the building that has already been regularized by the committee also,
Yes, ma'am.
it
In
can't help.
such an event, kindly
Compensation.
consider allotting a equivalent land abutting the road is my specific submission. It's for my lord's
That
consideration.
also we can explore.
Yes,
We can explore
Yes,
that
ma'am.
also
As-
if possible.
If your property is abutting the road.
yes, my lord, as of now. With
no,
regularization.
All right, abutting the road and road passes by,
Yes,
we direct them to allot another property abutting the same road?
yes, ma'am. After the road gets widened, if the 80 feet road becomes 120, I lose 40 feet of my land. Kindly, in any case, that land is vacant. It is not the case that in a case where,
Else that BDA will
yes,
explore.
ma'am, if that is considered,
We
it may
cannot
be
implore
close to
upon the BDA
akin to
explore that.
akin to restitution is my respectful submission. If
We'll
we
consider.
got the citation, I will pull out the full case
Like,
law and produce
Cody,
it.
that
But at least
you Wednesday will have it. Sir.
1996 SCC 221.
We'll resolve this.
yes,
problem. You also get everything.
Only with respect to the
1996,
compensation, with respect to the illegally constructed structures. are
ಅದು and to resolve the whatever ಈಗ ಇವ್ರೇನು ಕೊಟ್ಟಿದಾರಲ್ಲ ಈಗ ಅದ್ರ ಬಗ್ಗೆ ನೀವೇನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ ಹರಳ್ಳಿ ಸರ್ ಏನೋ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ.
Mr. Harnalli, Wednesday will be all right for you. Afternoon.
ವೆಡ್ನೆಸ್ಡೇ 3:30
ಆಗ್ಬೋದು.
Agboda? Many aspects ಇದೆ. Just I was
ಇಲ್ಲ,
contemplating.
we
what
may
will be-
require some more time for study, but I subject to what you are.
5 ದಿನ
ಹಾ
5 days ಇದೆ.
ಅದೇ ಆಯ್ತು.
You have team, we know you have that big team of experts.
ಯಾವ ಟೀಮ್ ಇದ್ರು
ಇದು-
ಕೊನೆಗೆ ನಾವೇ ನೋಡ್ಬೇಕು.
Will also
ವೆರಿ ವೆಲ್.
agree with, we will also contemplate about that. ಯಾಕಂದ್ರೆ ಅದು
ಬಿಕಾಸ್ ಇಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಫಾರ್ ರೀಚಿಂಗ್ ಎಫೆಕ್ಟ್.
That is what.
ಈಗ ಎಲ್ಲಾದ್ರೂ ಒಂದು ಫಾರ್ಮ್ ಹೌಸ್ ಕಟ್ಟಿರ್ತಾನೆ, ಈ ಫಾರ್ಮ್ ಹೌಸ್ ಗಳಲ್ಲಿ ಮೆಜಾರಿಟಿ ಆಫ್ ದ ಕೇಸಸ್ ಏನು ಪರ್ಮಿಷನ್ ಇರಲ್ಲ. ದಟ್ ವುಡ್ ಬಿ ದ ರಿಸಲ್ಟ್ ಬ್ಲಡ್ ಇಟ್ ವಿಲ್ ಹ್ಯಾವ್ ವೆರಿ ಫಾರ್ ರೀಚಿಂಗ್ ಎಫೆಕ್ಟ್. ಒಂದ್ ಸ್ವಲ್ಪ ಮೇ ಬಿ ಇನ್ ಎ ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಚುಯೇಷನ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಆಸ್ ಕಂಪೇರ್ಡ್ ಟು ಸಮ್ ರೂರಲ್ ಏರಿಯಾ.
ಅಲ್ಲಿಯೂ ಆ ಪ್ರಶ್ನೆ ಬರ್ಬೋದು.
ಹಾ
ಇಲ್ಲಿ
ಬರುತ್ತೆ.
ಏನು-
ದಿಸ್ ವಿಲ್ ಹ್ಯಾವ್ ವೆರಿ ಫಾರ್ ರೀಚಿಂಗ್ ಎಫೆಕ್ಟ್.
So consider my matters.
And what happens, Lord, where? What happens is when a building is completed, portion of it is authorized, portion of it is unauthorized. Then what should happen also would arise.
Apportionment to
ಹಾ ಅದೆಲ್ಲ ಬರುತ್ತೆ issues, lot of.
ಅಲ್ಲ ಇದು ಹಿಂಗ ಆರ್ಟಿಕ್ಯುಲೇಟ್ ಮಾಡ್ಕೋಬಹುದು. Whether
Entire building is unauthorized, but Lord stands on one different footing.
position, but principle will be same.
But in a case where suppose,
Separable.
ಹಾ,
ಅವಾಗ ನೋಷನಲ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಅಪ್ಲೈ
ಅದೇನಾದ್ರು ನೋಡ್ಬೇಕು ನಾವು.
ನೋಡ್ಬೇಕು. ಸ್ವಲ್ಪ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದೆ, ಮೊಡಾಲಿಟಿಗೂ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದೆ. ಬೇರೆ ಪ್ರಪೋಸಿಷನ್ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗಿಲಿಲ್ಲ. ಹೌ ಟು ಡಿಸೈಡ್ ವಾಟ್ ಈಸ್ illegal,
ಅಲ್ಲ
what is not illegal,
ಪ್ರಪೋರ್ಷನಾಲಿಟಿನೂ ನೋಡ್ಬೇಕಾಗುತ್ತೆ.
is unlawful. Which
ಅಲ್ಲ,
is the
proportional-
best idea which my brother gave. Of course, he goes on giving.
ಅವ್ರಿಗೆ
so
ಬಹಳ
many
ಐಡಿಯಾಸ್ ಇದೆ ಅವ್ರಿಗೆ.
regularizable.
ಅಲ್ಲ, ಅದು that will be very difficult, my lord. What I would suggest is that applying the doctrine of proportionality, if the major portion of the building is unauthorized, then that should stand on a different.
That also is.
If substantial portion is unauthorized, substantial portion is authorized, then it could
Then
be.
the doctrine of severability.
ಅದೇ.
What is
Doctrine of substantial compliance can be considered. Our idea bala strict adu, bala very, will have very far reaching effect.
No, regularizable andre.
Andre regularizable is only 5%, my lord, according to Bangalore BB.
So ಈಗ then proportionality is what you said. We have to draw in, as lordship said, severability.
what is not regularizable? ಅಥವಾ notionally
See,
severability.
if it is on the face of it illegal, a particular portion,
Ah.
we will have to weed out that
Suppose there
illegal.
are judgments which say you should pull down the building and you have not done that. Even for that compensation should be paid to you.
That's exactly it.
So many.
There are
at least
two,
12 situations I
my
contemplate.
lord, opposite situations. There are two.
Far-reaching consequence ಇದೆ.
ಅವ್ನಿಗೆ ಗೊತ್ತಿದೆ ಈಗ ಅನ್ಸುತ್ತೆ. 96
They should be pulled down. And another is, can state pay something for illegality? The compensation is paid from the exchequer, although it goes to the exchequer. Then it is paid, whichever be this one. Where can we do something which amounts to placing premium on illegality?
That is answered in 1996, but we have to see the evolution of the law thereafter.
That's right.
If something
Exactly
comes
the
out
point.
of it.
That's all.
96 has answered in a very positive way what my lords are holding. But we will examine it whether
Yes.
post
That is why
96 there is a change of approach by the Supreme Court.
Now, this 96 Supreme Court is a one-page judgment where they say, one page ಇರೋದು, ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಹಾಫ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದಾರೆ, ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಇಲ್ಲ, ಬಿಲ್ಡಿಂಗ್ ಇಸ್ ಅನಾಥರೈಸ್ಡ್, ಯು ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ಡ್. ಬಟ್ ಟು ಲೇ ಡೌನ್ ದಿ law in all situation is, as your lordship rightly put it, beloved, the building itself is without plan.
the whole building.
Or a case where partially there is a license, partially what should be.
ಈಗ ತಮ್ಮ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ರಿ 2 ದಿನ ಮುಂಚೆ ಇಲ್ಲ 2 ದಿನ ಆದ್ಮೇಲೆ ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. Those are buildings which come within that proportionality thing and do it because they are regularizable because license is already granted.
Or doctrine of Bangalore construction, where sanction is for 1 floor and you will put 3 floors. That also, again, so many aspects ಇದೆ.
And Bangalore
Simple ಇಲ್ಲ.
construction is saved by way of the regularization scheme.
ಅದು ಅಷ್ಟಕ್ಕಷ್ಟೇ.
ಆ
ಸ್ಕೀಮ್
scheme ಅದಿರೋದ್
ಅದು
50
ಇದ್ರೂ ಬರುತ್ತೆ.
ಬಂದಿಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಆಕ್ರಮ ಸಕ್ರಮ ಸ್ಕೀಮ್ ಇನ್ನೂ ಹಾಗೆ ಇದೆ.
ಸ್ಕೀಮ್ ಅಲ್ಲಿ a biggest benefit is available for that's what is the contention and the Supreme Court has to decide.
No, that is
Is
stayed
to
there.
decide. Akrama sakrama.
That is stayed there.
Yes, ma'am. Yes, ma'am. So to the extent it is finality is not.
You see, Bangalore
No,
construction.
that is for retaining the structure as such, not for compensation. For compensation, again, different shades, as Mr. Arnoldi said.
Yeah, what sir said is that correct.
appears to be-
Proportionality,
Ah.
see. Stricto sensu, if you go by the law,
ಯಾವುದಕ್ಕೂ ಕೊಡಕ್ಕೆ ಬರಲ್ಲ.
ಅಷ್ಟೇ.
No, no, we are in the hands of the honorable bench where the reliefs are getting molded. To that extent, this.
So just now ideas are getting ಅಷ್ಟೇ. ಇನ್ನು relief ಬಂದಿದೆ. Ideas are
I
getting.
stand corrected then.
Let us see. Because this has to be a multi-dimensional.
ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಬಹಳ ಇದೆ.
But
ಹಿಂಗೆ ಆಗ್ಲಿ ಹಂಗೆ ಆಗ್ಲಿ.
Since your lordships will be laying down law, blood, not just for Bangalore. So it
Any
will have-
application.
Yeah, entire will have far-reaching consequences.
No, everything should be explicitly said in this.
ಹೌದು.
There will be ಅಲ್ಲ. ಅದಕ್ಕೆ bona fide development authority.
Positive compliment.
ಅದಕ್ಕೆ ಅಲ್ಲ
So ಅದಕ್ಕೆ ಶಂಕರ್ ನಾರಾಯಣ್ was saying, I will appear as amicus curiae before BDA ಅಂದ್ರು. ಅವ್ರ ಮುಂದೆ ಯಾವ amicus curiae ನಡೆಯಲ್ಲ.
Court ಮುಂದೆ.
But there are 5 matters, my lord, which are not part of this.
ಇದು
road
ರೋಡ್
matters.
ಈಗ ಯಾವ್ಯಾವ್ದು ಇವತ್ತು ಇಂದ್ರಲ್ಲಿ
Serial number 5.
Interim orders have to be extended in case.
Interim orders will extend. ಯಾವ್ದ್ರಲ್ಲಿ interim order ಇದೆ ಅದು?
Serial number 5, 6.4.
6.4.
Yes,
5 is not part of the
5
road.
is not part of road. 6.4.
The Rohan,
Yes. That's a-
but there are other issues
Yes.
also. 6.4,
5 is road. 6.4, sir.
6.4, ಅದು ರೋಹನ್
7,
ಜಗದೀಶ್ ಆಚಾರ್ ಇದು ರೋಡ್ ಅಲ್ವಾ?
no,
ರೋಡ್ ಅಲ್ಲ ಇದು.
no, serial number 9.
ಅದ ಎವ್ರಿಥಿಂಗ್ ಎಲ್ಸ್ ಇಸ್ ರೋಡ್.
18 and 18.2. They are not on road. They are not. Serial number 18 and 18.2. It may be called on
This
Six.
will call on 6th.
6th. my lord.
These
The
matters.
other matters on Wednesday.
Other matters on 3:30 and few other. ಇದು ತಗೊಳ್ಳಿ. ಹರ್ಡ್ ಎಲ್ಲರದು ಹಾಕೊಂಡ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಇದರಲ್ಲಿ ಡಿ ಟ್ಯಾಗ್ ಅಲ್ಲ ಡಿ ಟ್ಯಾಗ್ ಅಲ್ಲ, ಡಿ ಟ್ಯಾಗ್ ಆಗಿರೋದು ಮಾತ್ರ. ಸೀರಿಯಲ್ ನಂಬರ್ 3, 5 ಡಿ ಟ್ಯಾಗ್ ಅಲ್ಲ, 3, 5, 7,
Well,
9
3 is part of the
Huh?
road. 3 is road.
ರೋಡ್ ಆಗಿದ್ದು.
Yes.
ಓ ಇವ್ರದೇ
Only
ಅಲ್ಲ,
5.
sorry.
5.
Starting from 5.
Starting from 5 is Chetan. 5, 7, 9, 10, 11, 12.
ಇಲ್ಲ ಇಲ್ಲ. 5, 6.4.
ಬರ್ಕೊಂಡೆ ಮತ್ತೆ ಕೊಡಪ್ಪ.
5, 6.4.
6.4 ಆಮೇಲೆ ಹೇಳ್ತೀನಿ.
7,
ಈಗ
9.
ಬರ್ಕೊಳ್ಳಿ. 5, 7, 9, 18. ಒಂದು ನಿಮಿಷ. 9, 18, 18.2.
And 6.4 also.
ಆ 6.4ಗೆ ಸಪರೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಡಿಲಿಂಕ್ 6.4 ಫ್ರಮ್ ದಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಮಾಡಿ ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ 6th. ಆಮೇಲೆ ಅದೇ ತರ 18 ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ವರ್ಡೇನಾ?
18 and 18.2 only.
18 ಪಾಯಿಂಟ್. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಲಿಸ್ಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ, ದಟ್ ಈಸ್ 4th, ಇಸ್ ಇಟ್? ವೆಡ್ನೆಸ್ಡೇ 4th at 3:30 PM ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
Please.
ಬೆಂಚ್ ಇರೋದೇ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಬಟ್ ಪ್ರಿಪೇರ್ ಅ ಪ್ರಾಪರ್ ಡ್ರಿಲ್.
ಹಾ,
ಎಸ್.
ನಮ್ ಕೈಯಿಂದ ತಪ್ಪು ಮಾಡಿಸ್ಬಾರ್ದು. ನಾವು ನಿಮ್ ಮೇಲೆ ಹಾಕ್ಬಿಡೋದು. ನಾವು
ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ಆನ್ 6th. ಈಗ ಈ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಇಲ್ಲಿ ತೆಗೆದ್ಬಿಟ್ಟು ಡಿಲಿಂಕ್ ಮಾಡಿ 6th. ಮಿಕ್ಕಿದೆಲ್ಲ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ at 3:30. 6.4 ಡಿಲಿಂಕ್ ಮಾಡಿ
ಇದ್ರ ಜೊತೆ ಹಾಕ್ಬೇಕು.
6th ಹಾಕ್ಬೇಕು. ಇದೆಲ್ಲ ನಾನ್ ರೋಡ್.
Yes.
ಮಿಕ್ಕಿದೆಲ್ಲ ಆನ್ ರೋಡ್.
On road.
Of course, very important. Of course, I felt that way. It's important.
ಗೊತ್ತಲ್ಲ? ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಎಲ್ಲೆಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು. ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಎಲ್ಲೆಲ್ಲಿದೆ. ಸೊ ವೆಡ್ನೆಸ್ಡೇ ವಿಲ್ಸ್.
ಆಮೇಲೆ ಏನೇನು ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ ಅದನ್ನು ಲಿಸ್ಟ್ ರೋಹನ್.
ಹಾ.
ಏನೇನು ಪ್ರಪೋಸಿಷನ್ಸ್, ಬಿಕಾಸ್ ಎವ್ರಿಥಿಂಗ್ ಶುಡ್
You title them and draw list of authorities on that. Everything you title and draw the list of authorities. Now you have heard us. So ಆತರ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಮಿಸ್ಟರ್ ರಾವ್.
Yes, ma'am. Yes,
ಹಾ,
I
ಆ
can
ರೀತಿ
do that.
ಮಾಡ್ಕೊಂಬಂದು
Yes,
ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಮತ್ತೊಂದು ಇಶ್ಯೂ ಹೇಳೋದು, ಅದಕ್ಕೊಂದು
ಇಲ್ಲ.
ಸ್ಟೇ, ಅದಕ್ಕೆ
Will be as comprehensive.
ನೀವು ಒಂದು
But we appreciate your fairness that you said.
Thank you.